Good morning, everybody, and welcome to an AEI webinar on the future of election litigation, and specifically the future of the independent state legislature theory in the aftermath of the Supreme Court's recent decision. My name is Adam White. I'm a senior fellow here at AEI, and we're very lucky to be joined today by three leading election law experts to have a discussion about what the Supreme Court decided and about what will come next. This week, of course, the Supreme Court returns for an entirely new year of cases, but just a few months ago, in late June, the court ended the last year's work, with a flurry of major decisions, including a major case on the power of state legislatures in federal elections. The case was Moore versus Harper. It was on what's often called the independent state legislature theory. Now, 3 months later, we're on the verge of a new federal election cycle, so we wanted to take stock of the court's decision, what it might mean for future congressional elections, and also what it might mean for future presidential elections. By we, I mean my colleague, John Fortier, a senior fellow here at AEI. John and I are joined by two of the nation's leading scholars of modern election law, Edward Foley of the Ohio State University's Moritz College of Law, and Derek Muller of the University of Notre Dame Law School. Professors Foley, Muller, thank you very much for joining us today.
It's great to be here.
Thanks.
John, thanks as always for being down the hall from me. Well, let's start with what the Supreme Court decided in June. We'll spend a few moments on that before we're looking forward. Derek, can you just give an overview of what the court actually decided in that case? What was the issue?
Sure. So this is a winding case that went through many permutations before we got our final decision. But just sort of very briefly, North Carolina redistricted its congressional maps. Its congressional maps were challenged in state court as an unconstitutional partisan gerrymander under the state constitution. That is, that the Republican-controlled legislature tried to entrench Republican members of Congress at the expense of Democrats and Democratic voters in the state. And the state Supreme Court, construing a handful of provisions of the state constitution, said, yeah, we agree with you. This is an unconstitutional gerrymander. They challenged at the United States Supreme Court under the Elections Clause of the Constitution, which says that the legislature of a state comes up with the times, places, and manner of administering elections, including congressional elections. And the challenge was, this isn't the legislature doing it. This is the state court construing the state constitution. And that exceeded the bounds of permissible authority that the United States Constitution grants. And the court, in a divided decision, but with a pretty solid majority here, I think, said, look, we understand that the text of the Constitution says legislature, but we've for a very long time recognized that non-institutional legislature actors have had a role in the process of coming up with rules for congressional elections, and citing back 100 years to cases where they said the governor can veto laws, where the people by referendum can strike down laws, where the people by ballot initiative can shift the authority from the legislature to an independent redistricting commission. And they say, we're not going to sort of intrude on that long line of precedent. And we're going to say that it's acceptable for state constitutions and state courts to check or constrain what a state legislature is doing when it is engaged in the act of coming up with rules for federal elections. But the court at the end had a caveat, and it said there are times where state courts can go too far. I said it doesn't exempt state legislatures from the ordinary constraints imposed by state law, but state courts do not have free rein. What does that mean? The court later says, we hold that state courts can't transgress the ordinary bounds of judicial review such that they arrogate to themselves the power vested in state legislatures to regulate federal elections. So I said, North Carolina, you lose here. This is ordinary judicial review. You conceded as much at oral argument. You said this is what North Carolina courts normally do. But if in some case, not this case, but maybe at some point in the future, some state courts will go too far, leaving that to the side about what it looks like. So that was essentially the heart of the holding here in Moore versus Harper.
Thanks, Derek. And we'll spend a fair amount of time on that caveat that you mentioned at the end of the Supreme Court's decision. But Ned, do you want to jump in? I'd love for your thoughts on the case and maybe sketch out just a little bit more the theory of the independent state legislature, maybe from the perspective of advocates for that theory. I don't think you're one of them, but if maybe you could describe what their argument is. For those who are keeping score at home, the provision that Derek alluded to is Article 1, Section 4 of the Constitution, which provides that, quote, the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. And then the provision goes on to describe Congress's own powers in that area. I mean, it does seem pretty straightforward at first glance. It says that the state legislature decides the time, places, and manners of these federal elections. Does that mean that the state legislature should have total control over it?
Well, I think both you and Derek are absolutely correct that the caveat is probably the most important part of the opinion going forward as a practical matter. And I do think it is a pretty clear warning to state judges not to go off the reservation, so to speak, and look like they're acting like legislators and policy makers, that if they stay in their lane and look judicial, whether interpreting a constitution or interpreting a statute, they'll be able to do that. And there'll be debates at the margin about whether something looks too judicially activist to be really judicial in nature. As important as the majority opinion is, Justice Kavanaugh's concurrence is important along the same lines. He is usually the most pivotal justice at the moment with the current composition of the court. So, if there's another case along these lines, he may be the center of gravity. Justice Amy Coney Barrett didn't join his concurrence and didn't write her separately. So a little bit unclear exactly where she is in relationship to the Chief Justice Roberts, but those three, Roberts, Kavanaugh, and Barrett, are going to probably hold a balance of power on the future of this doctrine. And what's interesting about Kavanaugh's opinion is he was willing to at least embrace a standard for implementing that caveat. And the standard would be that articulated by Chief Justice Rehnquist back in the Bush versus Gore decision, which is very familiar to anybody who follows election law or has for the last 20 years. And so we could discuss that. I think not embracing that standard was necessary to get the liberals on board with the caveat. And there's some discussion of Justice Souter's alternative depiction of what it means for a state court to go off the reservation and not look judicial in its interpretation of a law. And what it was partly interesting about what Justice Kavanaugh said is that he thought, as a practical matter, it really didn't make a difference how exactly you formulated the caveat, whether it was in Rehnquist's words or Justice Souter's words or in the words that the Solicitor General offered at oral argument, that as long as there's this notion of the caveat, it does give this supervisory role to federal courts, including the U.S. Supreme Court, to make sure that state courts don't get out of line and become too fast and loose or freewheeling in their exegesis. And that's really an important thing. And I think that's the shot across the bow, or the warning that will be relevant, I think, in this cycle and so forth. But Adam, you did ask, and so I'll be quick, what was this theory that got rejected and what's left on the table? And I really think there have been, up until the rejection of the aggressive version, there are really two different versions of this theory. One is knocked out and is no longer in play, but the other one is very much alive. So the aggressive version, which I guess really emphasized the independence of the independent state legislature theory, would have freed a legislature from things like gubernatorial vetoes or referenda. It would have required overruling previous precedents, as the majority opinion says. So it was an attempt, to try to get the court to go off in a different direction, reject precedent, and be very aggressive. And there wasn't the stomach or the appetite for that. So the pure independence of the legislature is no longer an option. But as you quoted the text of the provision, the natural, inevitable reading of the language gives primacy to the legislature, whether we like it or not. If we were rewriting the Constitution, would we do it this way? That's not the point. The point is, this is a provision. It's not only a provision in Article 1 of the Constitution. That was what was in play in the North Carolina case in the context of gerrymandering, but this applies to both congressional elections in Article 1 and presidential elections in Article 2. And because both similarly say that, that state legislatures have this authority to write the rules. It's actually even more in the legislature's hand in the presidential context, as we'll get to, because Congress can rewrite the rules for congressional elections under Article 1. Congress has no power to rewrite the rules for presidential elections in Article 2. And so you have to look to what the state legislature does in setting these rules. And then, given this caveat, but given the acknowledgement that judicial review is appropriate, there is a role for state constitutional law to constrain the way a state legislature implements that. So an example in the court's opinion is the concept of a secret ballot. Many state constitutions early on in American history said we're going to do vote, or not even a secret ballot, just voting by ballot instead of so-called viva voce. In the old days, colonial era, people would go to a town meeting or their local gathering and just vote out loud. But state constitutions say no, elections will be conducted by secret ballot. And they expected that to be a provision applying both to state elections, like for governor or state legislature, but also to the federal elections that states organize, congressional elections, any other election. And the basic implication of Moore versus Harper is that kind of state constitutional provision is okay, and the state judiciaries can enforce it in the context of federal elections. And so independence doesn't repudiate those kinds of things.
Thanks, Ned. John, do you want to jump in? Any opening thoughts on Moore versus Harper and what was at issue and what the court decided?
Yeah, staying away from all of the standing language, which was substantial in the opinion. I was interested that the larger part of the argument took on the broad theory where it might have taken on a narrower chunk of it. Ned and Derek referred to it, but this independent state legislatures theory or doctrine, there are quite a number of mentions of legislatures in the Constitution and what their duties are, and you can parse out and find different ways in which it operates. But I think one of the reasons we were focused on this was because we have this political and legal challenge that's going on. Broadly speaking, we have a number of states with Republican state legislatures. We have, I think, Democrats thinking they can rely and go to state courts more for their decisions. And worries in the presidential election context, with presidential electors, and other ways that these state legislatures might step in, and that's somewhat undemocratic or overthrowing the people's will. And maybe courts would be better defenders of the people's will in that way. So the way in which our political debate has set this up, maybe caused the court to sort of take this on more broadly. They might have just said, look, not only just the elections clause, but even just the redistricting cases. Redistricting cases are arguably pretty particular. They're going to be written in law, and that's some of the court's decision. But the court took this broad theory on. By doing that, they actually essentially spent a lot of time reworking or restating the Marbury versus Madison over the theory of courts, the theory of judicial review for state courts, and made a bigger point about it than they might have. The other areas which I think matter for this is that yes, the court did try to distinguish certain types of actions by legislatures, ones that we think of as not legislative, and I think that's probably the big distinction they're trying to put down. When a state legislature has to act in law, to pass an election code, to pass a redistricting map, then it's going to be more in the judicial review realm. When it used to in the old days elect senators, or when it ratifies constitutional amendments, or even does some things related to granting land agreements to the federal government, it might act actually as a body. And So again, I think the court could have taken a narrower view, but decided to spend a lot of time laying out this bigger theory. I do have some questions about it. Some of them which you could ask about: are there different aspects even within the elections clause of different types of things that state legislatures might enact in election code? But on the presidential level too, and I'd be interested in what my fellow panelists have to say about this. But thinking about the differences between the elections clause, the electors clause, where clearly, at least early in our republic, we had state legislatures appointing electors directly. That seems to me more like an election of a senator, maybe one that doesn't require a law. And I think some implication in this case that that state constitutions can limit that power as well. I don't think we're planning on going back to that as a general practice. But the court took a broad view of all of the elections things as being in judicial review. What again I would add on the caveats, you do have both the decision, Kavanaugh trying to flesh it out a little bit more, what the standards might be for federal court to actually go in and look at the work of a state court. And then you have Thomas in the dissent talking about what he thinks what kind of a disaster will be. And essentially he is saying that it opens up the docket to lots and lots of challenges of state court decisions, which will be summarily dismissed in generic language. But there is that unknown category of things that might come up as a surprise and an emergency at a contentious time in the election that we have really no definition for, that might actually reopen these questions. And I think that and all of the caveats plus the decision really affected the media coverage, where the media in some ways reported, well, this big doctrine has been shot down, it's closed off, and yet this somewhat amorphous opening for the interpretation of state law by federal courts at certain key times of the elections is still left there as maybe a very narrow thing, or maybe a wild card in key points in an election.
Thanks, Sean. As we've discussed now so far, all the issue or all the precise issue in the case of Moore, even though it was about state legislatures and federal congressional elections, the litigation played out against the background of presidential elections. So why don't we just talk about that directly now? As we said, Article 1 deals with Congress and how it's elected. Article 2 of the Constitution is on how presidents are elected. And it says right away in Article 2, Section 1, each state shall appoint in such manner as the legislature thereof may direct a number of electors. So not exactly the same as the language from Article 1 on congressional elections, but very, very close. Ned, Derek, how should we think of the relationship between the Article 1 provision and Article 2's provision for presidential elections? How much did Moore v. Harper actually have to do implicitly with presidential elections?
Oh, a lot, I think. I think even though the case was about congressional redistricting, I've always thought that the main fact pattern that was front and center in the minds, at least of the more conservative justices, was the litigation in Pennsylvania in 2020 over the extension of the deadline for the return of absentee ballots. That had provoked some separate writing among several of the justices, including Justice Kavanaugh. And at one point, it looked quite likely that they might take that case in the midst or the run-up to actually voting in November of 2020, because many observers, especially on the more conservative side, thought that the Pennsylvania Supreme Court in a 4-3 decision, in a kind of a partisan 4-3 decision, did kind of go off the reservation. And maybe just a review of those facts for those who don't remember that case is useful. It also should be thought of in relationship, again, to that Bush versus Gore litigation of 20 years earlier as a sort of a similar circumstance, obviously more fraught with all those hanging chads and so forth, but much more recent and much more vivid in the minds of the current justices was during the 2020 election, because of COVID, there was this debate about how much absentee voting there would be and what the rules around it should be. And this one played out in different states in different ways. In Pennsylvania, as in other states, some people sought an extension of the deadline. Pennsylvania, like many other states, said that absentee ballots need to be returned by the time that polls close on election day, 8 p.m. Basically, half the states, or maybe a little bit more, have that deadline, but other states, whether because of COVID or just generally, are more generous and say as long as state ballots are postmarked by election day, they can be turned some period of time later. But Pennsylvania did not have that rule. People more on the left wanted that kind of extension because of COVID. You'll recall there was concern about the post office during that summer and fall of 2020, and would people get caught up with the inability to actually get an absentee ballot to them from the government and effectively returned. And one of the the Pennsylvania Supreme Court, by a divided 4-3 vote on its own initiative, changed the deadline, even though the statute for the deadline was absolutely clear. The only constitutional provision that was relevant was the generic free and fair clause of the Pennsylvania Constitution, which has existed for centuries, long before anybody ever thought of something called absentee voting. And it was analogous to the free and fair clause in the North Carolina case being used to restrict redistricting. But in the Pennsylvania context, it was used to change the rules for when absentee ballot gets returned. So it was kind of the poster child for those who think a Supreme Court was usurping the function of the legislature and engaging in a legislature. It didn't have a clear constitutional rule like there must be a secret ballot or there must be absentee voting or whatever. It was just there should be free and fair elections. And now the majority, the 4-member majority of the state court, was kind of deciding on its own what a free and fair election was, when the legislature, right or wrong, had said, nope, we're not going to extend the deadline for absentee voting. And I think the most significant thing in the dissent of the state Supreme Court, the Pennsylvania Supreme Court, was said, look, yeah, there is a real concern here about a time crunch between the time for applying for an absentee ballot and then the time for returning it. And if the postal system is in trouble, innocent voters might get caught. But if we're trying to figure out what the legislature would want to do, given a time crunch, the thing most consistent with the way the legislature constructed elections would be to change the deadline for when you request an absentee ballot, so you comply with the obligation that all ballots get returned at the same time. So even if there is a judicial remedy, the judicial remedy is not the one the majority wanted. Anyway, so that's where this same theory, the independent state legislature theory, was invoked in the heat of the presidential election in a battleground state to say, the state courts changing the rules. And, had those ballots made a difference to the outcome of the 2020 election, it would have been Bush versus Gore all over again, or arguably worse. But, despite what Trump said, it was not a close election or close enough. Pennsylvania was won by some 80,000 votes, but those ballots that were affected by the deadline were sequestered by an order of Justice Alito, another one of the justices who were interested in this. And even after the dust got settled on the presidential election, you had some justices like Justice Thomas saying that despite mootness concerns, they should settle this issue in that context as opposed to waiting for the North Carolina case. So when that didn't happen, cert was denied after the emergency motions were denied, but it was quite divided. It was right when Justice Barrett was replacing Justice Ginsburg, and sort of unclear whether there were going to be 8 justices or 9 justices able to rule on this. So it got a little messy, but it got deflected and ultimately didn't matter to the outcome of the presidential election. It gave denialists a talking point to complain about the way Pennsylvania was conducted, maybe rightly so, but didn't make a difference. In any event, again, I think it was very much front and center on everybody's minds when Moore versus Harper was decided. And I think the purpose of the caveat implicit but pretty loud and clear, is Pennsylvania Supreme Court, we're watching you, or any other thing like that. And so the decision, I think, has just as much an applicability for that kind of context. So as you mentioned, Adam, we're coming into a new election cycle. If state courts kind of mess around with the rules of elections, the caveat could be invoked. Now, there are a couple of other points I could make, but I've kind of talked long enough, so let me leave it at that for this round anyway.
Could I jump in just to add?
Sure, go ahead, John.
What Ned says is absolutely correct in some ways. These are Bush v. Gore type issues, but this happened more particularly in the context of the so-called Purcell principles, that if this had been a federal court decision, presumably happening in a time close to the election, the court ruled many times to keep its own lower courts from making changes that, as they would put it, to the election, close to the election. But they were, reluctant to maybe do it in this case. And I think that's one of the areas where, again, this standard that whatever it is, it might be different for Purcell cases. The Chief Justice didn't seem to be enthusiastic about applying it to state courts, at least in the several of the cases. But maybe, this is something that says, well, yes, on the substantive things, we might have to define what areas fall in this or not, but maybe a kind of Purcell principle, a not bringing state changes, state suits that make changes to election procedures that affect federal elections in an X number of day period would be something that would fall in the standard. So I think this is an area that the court is clearly going to keep on its Purcell doctrine from the past with the federal courts, but what it does with the state courts, I think, is still quite a live issue given the caveat.
Derek, anything to throw in on the presidential issue?
Well, let me just jump in on the Article 1 versus Article 2 point briefly. So Article 1 empowers Congress to make or alter those rules in congressional elections. So you can actually shut down basically all legislature thereof claims when Congress acts, and when Congress steps in to provide absentee rules for uniformed and overseas citizens, when Congress steps in to provide voter registration rules, when Congress steps into the breach in these areas, you are not dealing with these questions of, well, which entity in the state is handling these questions. You have federal supremacy and you have uniform rules and you have some consistency of application. So there is, I think, broad political power, if not will, in Congress to address these issues and preempt some of the concerns that might arise in the piecemeal fashion in the states. You don't have an analogous power expressly under Article 2, and this creates some interesting dynamics. So one is the Supreme Court has long assumed that Congress has coextensive power under presidential elections through a long series of precedent. There are people who are trying to challenge that precedent in the lower courts right now. Arizona is one of them, challenging that distinction between presidential and congressional elections. So I don't know how long it'll hold up. Congress has a lot of other rules at its disposal, or a lot of other provisions of law at its disposal, the Reconstruction Amendments, for one, to think about empowering Congress to regulate how elections proceed. And then another is Congress's authority under the 12th Amendment, thinking about the Electoral Count Act and the Electoral Count Reform Act enacted last year to say, we can regulate the time of holding presidential elections, and that can include shutting off any kinds of notion that we're going to have an appointment of electors after Election Day. We're going to shut off the opportunity to change the rules after Election Day. And I think a successful bipartisan effort in Congress to make sure that those rules are tightened up around presidential elections in particular. So there are some, I think, dynamics between Article 1 and Article 2, while they're both using legislature, different roles of Congress, but ways that Congress has tried to put some pressure in the right way to prevent states from manipulating or having some disputes about these rules in presidential elections. Not perfect, and of course requires political judgment in Congress, but certainly an omnipresent concern.
And now, could I just add on that?
Sure, John.
when we think back to Bush v. Gore, we sometimes think of the much stronger argument of the theory in the 3-judge concurrence, which Justice Thomas is the only remaining member. But there's also this legislative point that Derek has brought up, both in the original or the older Electoral Count Act and the amended. You do have language that essentially tries to enforce the idea that the legislature, or by law, an election code should be put in place before the election, and it should be a known thing, and electors should be chosen ultimately by that code and not by some sort of changes that happen after the fact. And this is actually this is in the larger decision in the court's opinion in Bush v. Gore. In some ways, the court said, look, the legislature clearly wanted to meet its deadlines. It wanted to put something in place that was there beforehand, so that the electors would be more likely to be counted by Congress. So there was some legislative intent by Congress to reinforce that principle. And that itself sort of opens up aspects of an independent state legislature theory there. At least it asks us to say, hey, if a court is changing what the legislature wanted, what this supposed to be fixed law is, then maybe they're going off the reservation. And I know that's a very broad standard. It doesn't really help us parse out what the court's going to do with these exceptions that they might have. But I think it's there both in the theory, but it's also there in the Electoral Count Acts, which try to flesh things out. That yes, there's a set election code that is supposed to be there and not to be changed by someone legislating after the fact, a court or an administrator.
And if I can pick up on both what Derek and John was saying, I think this is a key point, because one of the ways this theory was invoked was in the hope or the fear, depending, I guess, on which side you were on in 2020, even apart from that Pennsylvania case and stuff, that legislatures would come in after the fact and just directly assert a power to appoint electors and to repudiate the certified result, whether in Arizona or Georgia or these other, and obviously President Trump, try, and his other people on his team tried to invoke that. And so, I think there was understandable resistance to that on the left. I think the left overstated the fear of this, because this doctrine was never going to support that particular extreme view for a variety of reasons, including, the ones that both John and Derek mentioned. First of all, Congress has a separate constitutional power in Article 2 to set the time for the appointment of the electors. And so as a constitutional proposition, however large the state legislature's role is in determining the manner of appointing electors, once they've determined the manner and once electors are appointed pursuant to that manner, it's over for that election. The appointment is over, and then they can change the rules for the appointment of the electors next time. That's constitutional law. The frailty of the system until the reform of the Electoral Count Act was actually in a provision of federal statute that allowed state legislatures to appoint electors in the context of a failed election. So that was not a constitutional doctrine. It got confused with an attempt to create this independent theory constitutional doctrine, but it was the Achilles heel in the system was a statutory provision that has now been buttoned down, as Derek said, by the statutory reform pursuant to a constitutional power that Congress clearly has. And as John also correctly pointed out, the fear of this ex post facto or after the fact changing of the rules that is part of the Bush versus Gore concurrence is a way in which a appropriately administered version of this doctrine serves the rule of law values that progressives and those on the left have been fighting for when they fear election subversion. I mean, so courts and its administrators and other officials can attempt to manipulate the results of electoral outcomes for partisan advantage, in defiance of what the rules of the road or the rules of the game are that are set ahead of time. And it was precisely the fear of that kind of manipulation that liberals really worried about that might occur when there was an attempt to get the Michigan Board of Canvassers to repudiate the canvass, and the rule of law held because the law is the law. You have to follow the rules. And so this doctrine that is basically, after the legislature writes the rules get followed as written, is in service of rule of law values. And I think everybody should think that's a good thing. And just to give you one concrete example of how the tables could be turned, and the partisan valence of this could be, mirror image of what it mostly was, again, in that Pennsylvania case, is imagine a state Supreme Court that says, we've heard that there are folks out there who don't believe that absentee voting is trustworthy. President Trump doesn't think absentee voting is trustworthy. The state legislature has created, no excuse absentee voting, automatic, universal, everybody has the right to vote by absentee. Well, we don't think that complies with our generic free and fair election clause. And so we're just going to completely eliminate absentee voting, or at least no excuse absentee voting, because of our interpretation of a free and fair election clause. I mean, that is the example of the kind of judicial activism. In that case, it would be in service of a more conservative proposition. And if you think it's theoretical, the Delaware Supreme Court sort of did a little bit of a version of this, not in the context of a presidential case. So, what's good for the goose is good for the gander if this rule is applied even-handedly and fairly, and it'll just protect the system, being rule following in presidential elections going forward.
I just want to pause here and say I'll have a few more questions of my own before we open it up to the audience. And for those who are watching this live stream, you can submit questions in either two ways. You can either send an email. The email address is on the page for this event, or you can go to that great bastion of eloquent debate, Twitter, and tweet us at #AEI elections. Okay, back to the litigation that might come in the wake of Moore versus Harper. And again, that caveat that the Supreme Court had about the relative powers of state and federal courts. I have to admit, when I first read the decision and those parts of the decision, it reminded me a lot of the Supreme Court's decision a few years ago involving congressional subpoenas. You had Congress asserting subpoena power over members of the Trump administration, the Trump White House asserting executive privilege in response. And the court ends up holding that, yes, Congress does have the power to grant these subpoenas and they're judicially enforceable. But the court added those subpoenas can only come from, and I can't remember the exact words, but something along the lines of a legitimate legislative purpose. And in that respect, then, it reminded me, or my takeaway from that was, while the court had ruled in favor of Congress, it had given, a fairly significant caveat to the other side of the case. And in this case here, in Moore versus Harper, I was struck when the case was actually litigated that the lawyers on behalf of the North Carolina legislature, they made nuanced arguments about the limits of state judicial power, the role of the state legislative power. The case as it was actually litigated was not the sort of clash of absolutes. The state legislature is in charge of everything versus the state legislature gets nothing. I mean, it was a pretty nuanced set of arguments, and the decision itself strikes me as pretty nuanced. So here, one more quote for today. This is at page 29 of the court's opinion, the caveat we've been alluding to very generally. And my question is going to be for the panelists, what does this actually mean in practice? So the quote is, state courts retain the authority to apply state constitutional restraints when legislatures act under powers conferred upon them by the Elections Clause. But federal courts must not abandon their own duty to exercise judicial review. In interpreting state law in this area, state courts may not exceed the bounds of ordinary judicial review so as to unconstitutionally intrude upon the role specifically reserved to state legislatures. Sorry for botching that towards the end. But we have here a very significant, but also very vague allocation of power between the state courts, the state legislatures, and the federal courts. Could somebody just give us a sense of what this might actually mean in practice? What's a case, not a easily dismissible case, but what are some of the harder cases that might arise along those lines of allocation of power between state courts, federal courts, and the state legislatures?
Well, I think that's the big unknown. So that's not going to be the answer. Maybe Ned has a better hypothetical here. I mean, so the court has done this in a couple of other places, and in Bush versus Gore and in more, they cite to some of these precedents. And I don't want to get too much in the federal court's weeds here, thinking about the adequate and independent state grounds doctrine. But the notion that if a state court goes too far in defining property rights, it could constitute a taking under the takings clause, and the property comes back to you. Or the state court can go too far in construing what a contract is under the contracts clause, that states are not supposed to impair the obligation of contracts. And that allows a federal court to step in and identify what a contract is. Again, quintessentially matters that we leave the state common law to determine, but like there's this constitutional backstop of, well, you just went too far. But despite those things cropping up, and especially with the takings clause in the last 30 years, federal courts have been very deferential, and they haven't said state courts have gone too far. Relatedly, for a long time now, I mean, for decades at least, there's been due process clause outer bounds to how state courts review state election codes. And a famous series of cases, Roe versus Alabama in the 90s, sort of gave some life to this notion that state courts can't just deviate from ordinary established practices, especially after the election, of looking at election codes and interpreting them, that it could rise to a due process violation. So that's also this background principle that applies to all kinds of judicial review that's arbitrary and capricious, but specifically in the election context. So I think given those things, given that we have some situations where the court has said, well, there are these outer bounds in these other areas, and given that we've said, well, there's due process bounds to how far the judiciary can go, I think there's this open question about, like, what's left here? The court just leaving the door open a crack that seems to invite a lot of litigation, but not a lot of success. So I don't know what's left for it. I think it's a pretty narrow gap, if any, but really does require the state courts to do their homework, to justify what they're doing, to provide the explanation for how they came to the conclusion that they did, and sort of leaving it for another day for the federal courts to step in and say, okay, you went too far, which in some respects we want more guidance. But then again, I think when the court has left these open-ended provisions in the past, it hasn't really found them terribly enforceable in later proceedings. But again, it's a wait and see approach.
So Derek, on that, just to follow up, so you're saying this isn't going to be a situation where the federal courts are just going to be sort of roving interpreters of state law, right? I mean, it's been a long time since I've taken federal courts, but I remember federal courts, federal Supreme Court especially, they generally don't. Well, in diversity, I guess they do, but the general basic rule is on cases over federal issues, we're not going to delve into the meaning of state law too much. This is not going to be the federal courts second guessing state courts or state legislatures on the meaning of state law.
Right. And I think I don't want to make this a federal court seminar, although I would love to make it that. There's not a lot of places where people are going to run into federal district court and be successful. If the state Supreme Court has done something, you're in a petition for cert, and the United States Supreme Court is mostly just going to summarily deny. If the state Supreme Court comes up with something that you dislike, and then you try to run into a federal district court somewhere, the federal district court it's going to say you're precluded, you have standing it has all these procedural hooks to throw the case out and say, we're not going to do it. In addition to that layer of saying, yeah, we defer to what state courts typically say. So I think there is very little likelihood of federal district or federal lower court mischief. And to the extent the United States Supreme Court is interested in getting in these cases, I think it's got a low tolerance for interest in like getting involved in these cases.
Great. Ned,
So
John?
Oh, can I give you a hypothetical where this, I think, could play out in a congressional context? And then if we want to a quite different hypothetical in the presidential context. In the congressional context, there's litigation in New Jersey right now under the state constitution by plaintiffs who want to go back to something called fusion voting. Some of the audience may know that term, others may not have heard of it. It's something that New York does. What it means is that a candidate can be simultaneously the nominee of two different political parties. And so like in New York State right now, a nominee could be the nominee of the Democratic Party and also the Working Families Party, or another nominee could be the nominee of the Republican Party and the Conservative Party. This was a widespread 19th century practice before the so-called government printed ballot, sometimes called the Australian ballot, that we adopted from Australia around the turn of the 20th century from the 19th century. But prior to that, parties printed their own ballots. And so sometimes the populist party would nominate the same candidate as either the Republicans or the Democrats or the Greenback Party. And so fusion sort of happened naturally in the context of politics. And so some states for a while allowed candidates to appear on the ballot under multiple party labels. In a Supreme Court case some decades ago, the US Supreme Court allowed Minnesota to repeal fusion voting and said that was not a violation of equal protection or the First Amendment and so forth. But there are members of the reform community who would like to bring it back. Now, one way to try to bring that back is to convince a legislature, like in New Jersey, to enact a new law to allow it, the way New York does and Connecticut also does. But litigants have gone to state court hoping to interpret a vague provision of state constitutional law, another one of these generic free and fair election clauses, and say an election is not free or fair unless you allow for fusion voting. Were state Supreme Court to take that position and sort of insist, contrary to the will of the state legislature, that you have to have fusion voting for congressional elections, as it indeed was specifically sought in this New Jersey case. That feels to me the kind of case that the US Supreme Court could say, that's usurping the legislature's role. The generic an election can be free or fair with fusion voting, without fusion voting. You might like it one way or the other, but that's not something that the judiciary gets to impose under a vague generic standard. That has to be a legislative choice. So, were that case to wind its way up to the Supreme Court, it would be potentially gives an example of a state Supreme Court just usurping the legislative role with respect to the manner of congressional elections. So there's one specific hypo that we could think about. And I guess it's a real case.
You were hinting at one of the presidential contexts, and I don't want to read your mind here, but I think actually that's something we might all want to talk about. I would like to hear from you, and that is, of course, this controversy on the 14th Amendment, Section 3, about this disqualification of the president. And might it be done, as some have argued, by a variety of state actors, perhaps courts, but even perhaps administrators. And an issue like that is obviously implicated by or can be related to this. So not that I'm not interested in fusion voting, but I would love your thoughts on that, and maybe take some time to sort of think if that is something. I mean, I think for the most part, we've seen secretaries of state and others start to sort of beg off on this a little bit and say, look, I don't think that's our role. We shouldn't do that. But it only takes one, really, and one court, one administrator, one secretary of state maybe to make this call, and then where are we?
No, absolutely right. And that was the thing I had in mind most for this coming presidential cycle. In other words, one way this Moore versus Harper issue could get back to the Supreme Court in the way the Supreme Court was forced to address it would be if if a state Supreme Court were to look at existing state law and says it empowers either itself, the judiciary, or a Secretary of State to invoke this disqualification provision, when there's no language currently existing passed by a state legislature that would kind of expect that or authorize that. So again, this has to be analyzed on a state-by-state basis. Every state has its own election code adopted by the state legislature, and Derek is actually an expert in this, and I'd love to hear from him in a second. But there are rules for if you believe a candidate is not qualified to be president, but the ordinary examples of that is, are they 35 years old? Are they a natural born citizen? Pretty straightforward factual issues. Did you engage in an insurrection or give aid or comfort to an insurrectionist? What does an insurrection mean for that Constitution? Is the president within the scope of the officer? There's just a whole set of issues. And so the Moore versus Harper issue, the independent state legislature doctrine, if you will, issue here is, even if you assume, as I do, that a state legislature has the power under Article 2 as part of its power to figure out the manner of appointing electors, a state legislature could write a state statute that says, here's how we're going to adjudicate in our state a Section 3 disqualification issue. We're going to have due process. We're going to do it this way. And here are the rules for that. If the statutory scheme can't reasonably be interpreted by a court to provide that already, and that's that notion of what is reasonable judicial interpretation. But that's where I think this caveat standard could come into play. If it's not reasonable to interpret existing state law to set up a mechanism, then if anybody takes it upon themselves, the Secretary of State or a court, to do it anyway, then they run up against the constraint of this caveat. So it could really come into play in the context, John, as you mentioned.
Derek, you have any thoughts on that one?
Well, yeah, let me just add, I think states have allowed ineligible candidates on the ballot for president all the time. This has happened for a very long time. It's not a surprise. Again, we usually don't think about it, but in terms of minor party candidates, non-citizens on the ballot, non-natural born citizens, underage candidates, because states just don't have rules or mechanisms to check them. The notion being this game isn't worth the candle. We're just going to allow the process to play out politically rather than through the legal process. But some states do. Some states do have an express mechanism to be able to evaluate qualifications of candidates. Some say even federal candidates. Very rarely, I'm not sure that any expressly mentions Section 3 of the 14th Amendment. But the legislature, to the extent it invites the judiciary or invites an election board to make some of these adjudications, at least takes that part off the table. And I think that's what we want, right? We don't want secretaries of state unilaterally deciding, here's how I'm going to administer the election today. And that's not a good look. We might say it's not good to wake up one morning and say, I'm going to decide if this candidate is qualified for office, any more than waking up and determining any other kind of election rule. So we want to provide that legislative backstop, the pre-existing rule of law principle that we come up with this way of addressing the question, rather than just expecting executive officials to enforce what they believe to be the law without having that legislative backing. So I think it's a reason why you've seen a lot of secretaries of state tapping the brakes on the notion that they hold this unilateral authority, and instead saying we're going to let the legal process play out, because it's often left to judicial or some other tribunal to make these decisions, not to an individual election official.
If I could offer just a note of worry here, I do understand we have a lot of pre-existing legal doctrines that will, I think, deter a lot of this litigation that might arise. Not about the 14th Amendment, I'm just talking in general, the post-Moore litigation. But for me, like the hardest case and the one that's most likely, it's not one where a state legislature after the election tries to throw out the presidential election vote in the state or in a district. It's the much harder case where a state legislature concludes either in good faith or it rationalizes itself into thinking that the state courts are just misapplying state law in a partisan way. And so you have the state legislature whipped up and convinced that it needs to that it's going to defend the pre-election day law that the state courts are usurping. The state courts are, of course, they believe that they're the ones defending the pre-election day law, and now it's the state legislatures that are usurping. And it's in that kind of conflict over what the state law actually meant and was intended to do before election day that federal trial judges and others will be there, will be called to decide really what the law meant before election day, and institutionally, who gets the benefit of the doubt here? Is it do we give deference to the state judges who are interpreting the law after the fact, or do we give deference to the state legislatures who wrote the law? Now that gets complicated by how long ago the law was written and so on, but it's that sort of fight over what the state law means that I think has the real danger of blowing something up.
Right. I mean, if you think back to Bush v. Gore, we think of the case, but there was a time where the Florida state legislature was talking about, well, if these things keep going this way and we feel like the law is really not being followed and changed, essentially, that we are going to step in directly. And one argument, I mean, I think the tenor of the Muller v. Harper is that that is more or less off the table. But we, the court, have this option of weighing in and supporting you, helping you out. So don't do it yourself. We'll do something like we did in Bush v. Gore to remedy that, but that someone coming directly might not do that. I still think there is a question. They did lump together both the presidential, the electors clause, and the elections clause, and while I think there are a lot of reasons why it would be a bad idea, and the new Electoral Count Act has sort of also put some cold water on this. But what is the relationship of the legislature's ability to appoint electors, which clearly was there and historically, and if they didn't have an election code and wanted to start from scratch and do that, I think it's a harder case to make when there's already a law in place. But some might make that judgment that power is still sort of hanging out there in the background. So I think it's the tenor of the case, I think, is to say, look, again, maybe we need that exception because there still is somebody who needs to defend that, and maybe that's a court in an extreme circumstance, but don't go at your own because we have that power if we're going to defend what you wanted.
We have a question from the audience. I want to get that into the mix. This is a question from Kevin O'Neill, and he asks about a case that was filed in federal district court in Michigan on the independent state legislature theory. We haven't discussed this case in advance, so I don't know the extent to which the panelists are read up on it, because again, it looks like it was only filed last week. But Kevin asks, or he says, the case is called Lindsay versus Whitmer. The issue is whether the independent state legislature theory makes citizen-based ballot initiatives on election law unconstitutional. So is the question, I guess, is can only the legislature and not citizen ballot initiatives make election law? I don't know if anybody on the panel is tracking that case so far, that issue. Can anybody respond to that?
I mean, just very generally, that seems like a sure loser after Muller versus Harper. I say that because we have Arizona's Independent Redistricting Commission case, which was also a citizen initiative, a ballot initiative to create this commission that would essentially take the power from the legislature and put it into an independent redistricting commission. And the court upheld that. And part of it is Justice Ginsburg's opinion there. Spends a long time talking about, well, the people of Arizona very much viewed the people as having this inherent authority. They view themselves as having this legislative authority. But I think it's not just constrained to very populist states like Arizona. I think it extends, and especially after Muller versus Harper, to the notion that the institutional legislature can be constrained by the state constitution or by state statutes. And that includes being constrained by provisions enacted by the people via initiative. So I'd have to see more about the specifics of it. But I think it's a very low likelihood of success given the Arizona case and the sort of shutting the door in Muller versus Harper to further challenges.
Now, correct me if I'm wrong, the Arizona case was not exactly decided unanimously, if I remember correctly. Right.
It's true. It was not decided unanimously, but Chief Justice Roberts, who led the dissent in that case, and very much views himself as an institutionalist for the precedent of the court, very much favorably cites Arizona in the majority opinion and says, like, this is sort of water under the bridge now, and this is where we find ourselves today. So I don't think there's a huge appetite on the court to revisit those precedents. And it's worth noting, even in Muller versus Harper, the effort was not to overturn Arizona. It was to say, these precedents can harmonize with our theory, which is a substantive procedural divide. And even Arizona kind of is a procedural question about which entity gets to do the line drawing rather than substantive rules, like Michigan's ballot initiatives have been about, absentee ballot rules and early in-person voting rules and whatever those things are. Again, that substantive procedure divide, as tenuous as it might be, in particular, think about Arizona's case, really seems to be closed after Muller versus Harper.
Yeah, I was just going to echo that the dissenters were potentially putting forward this theory that, what is the legislature? A number of the cases, the redistricting cases in particular, commission cases, the legislature doesn't involve a referendum. Is it the whole process? Is it the legislative process, including a court necessarily being able to review this? And then are there other things that that shouldn't be in state constitutions that courts shouldn't enforce against them? Muller v. Harper really does. I mean, I think with its very full-throated defense of Marbury versus Madison, the theory of judicial review. I mean, the pages spent on that are to say broadly, this is a theory that not only the legislature can be defined more broadly, but there's a process that once something goes in law, whether it's substantive or more procedural, that is something that is subject to judicial review.
Adam, can I jump in with one thought?
Yeah, go ahead.
You I think correctly are trying to anticipate like what could go wrong given the caveat of this doctrine, or how could this play out? And one big picture thing to look out for is what will at least 5 members of the current U.S. Supreme Court think of as appropriate judicial interpretive conduct by state judges, and that could go in a couple of different ways. I mean, if you just think about debates in the court itself over textualism, originalism, purposivism, the years and years of debate between the Justice Scalia view versus the Justice Brennan view and the modern, Justice Breyer. I mean, so these justices have good faith disagreements about the nature of constitutional interpretation when they're interpreting the federal Constitution, and each of them views their interpretive method as the right one, and the other side's interpretive method is, inappropriate. And so one question which was not answered in Muller versus Harper, or even by Justice Kavanaugh's amplification, is the court going to adopt what we might call an ecumenical view of permissible judicial interpretation? In other words, and again, this will require thinking about where the balance of the power in the U.S. Supreme Court is on this. So let's say Justice Barrett or Justice Kavanaugh think, okay, I have my own view about the right way to be a judge and to do interpretation. And if a state judge isn't doing it the way I think it should be done, well, then they're not acting appropriately judicial. That would be a pretty strict and more aggressive version of this theory. And I think that's possible. It's also possible that they could say, well, if a particular state Supreme Court is true to its own theory of interpretation, they're citing their own precedents, they're using their own methodologies, And so they really look like they're being judicial according to their own judicial theory. It might be not my theory, it might be Justice Kagan's theory sitting in a state court, but I'll let them be their kind of judge that they want to be. That's a much more relaxed version of this doctrine. It's like, you don't have to be my kind of judge as long as you're really being a judge. But to the extent that more conservative judges think that more liberal judges aren't really being judicial in their method of interpretation, that could make this a more aggressive doctrine. And we just don't know the answer until we see that in practice.
And can I just add that if there's the general worry about the way in which maybe federal courts should be deferring to state courts, there's also just the practical difficulty of, if you really were to adopt some sort of standard that said, well, are you following your own precedents, or for the Supreme Court to jump in, let's say in a relatively emergency situation in a contentious election, just as Thomas put it that way, and then become an expert on state law and state precedents on these election issues. I mean, that's a practical task that is extremely difficult for the court, as well as perhaps something they shouldn't be involved in.
Let me ask one last question before we close. I feel like we've covered just about every possible office here. We've talked about Congress, state legislatures, state judges, federal judges, presidents, or at least the election of presidents, but we really haven't touched on two of the offices that were the most debated in the last presidential election: the role of the vice president in presidential elections, and the role of governors in presidential elections. We'll leave the VPs aside just in these last moments here. How do governors play into all of this? The upcoming possible litigation around state legislatures, in state courts. There's been a lot of talk in the last few years, worries about governors going rogue in their role in presidential elections, not a constitutional role, but a role assigned to them by Congress and the old Electoral Count Act. The recent Electoral Count Reform Act has recalibrated the role of governors, and it's subjected it to some federal judicial review. Any closing thoughts on how governors are going to fit into the things that we've been discussing this morning?
Well, again, I think we can think about different roles that the states give to governors or other election officials, and say most of the challenges are to secretaries of state, who tend to run the elections and tend to have more discretion over the rules for administering the elections and promulgating administrative codes, and making those sorts of determinations. So we don't often think about the governors as much, but certainly governors are obligated under the Electoral Count Act, and even more so, if I can say that, under the Electoral Count Reform Act, to sign the certificates of election for presidential electors consistent with the results that come to them. They don't have some sort of unilateral authority to ignore the results of an election or to certify some other winner. If they do so, I've written an article, it's forthcoming in the William and Mary Law Review, talking about the writ of mandamus, where you can go often directly to the state Supreme Court and say, hey, the governor is doing something inappropriate. Governor has a ministerial obligation to just sign the sheet of paper to pass this along and doesn't have discretion. So I think we're going to see a universal, well, there will certainly be challenges to governors to say, do the right thing, if you will, to quote some of Trump supporters' language, in governors of Arizona or Georgia, who did the real right thing, which is certify the results and not try to undermine the certified results that come to their desk. We're going to see that pressure, but again, no governors took the bait in 2020. I doubt any will in 2024, although there will be pressure placed upon them, and one can see. But I think there are some, again, strengthening Electoral Count Reform Act, plus existing mechanisms in state court to make that less of a worry than we might otherwise think about.
And just to add to exactly what Derek said, there's one particular provision in the new Electoral Count Reform Act that indicates that that when it goes to Congress, if a court orders a governor to do something with respect to the certification because law requires it, and the governor, really goes rogue and tries to disavow the court order, as you said, there's special judicial review procedures. But ultimately, as I read the revised law, Congress is obligated to follow the judicial account of what the true law is, not the governor's own interpretation of it. So the governor is really ministerial, both maybe as a matter of state law, but also as sort of a matter of the way the federal electoral count process works. So which I think is a good reform that was really adopted, and we should be glad that it's in the new law.
Thanks, Ned. John, I guess you'll get the last word. Any closing thoughts on this or anything else?
Just quickly, both Derek and Ned talked on about the Electoral Count Act and role of governors, but I think we won't see it as much because 2020 was, because of the epidemic, was a pandemic, was a extraordinary circumstance. But we saw cases where there was a question of not only governors but health officials, other executive branch, certainly secretaries of state, officials who might be doing some things on seeming emergency basis, maybe really needed. People are divided about these things. I mean, again, this does implicate this independent state legislatures theory. If the Supreme Court wanted to jump in, not against a court, but against some official who did this, because there was just a changing of state law. I mean, I suppose the opening that is there in the more fleshed out in the Kavanaugh concurrence, but also in the opinion, that there probably is the opening to do that as well. So this is not just the court has some opening to talk to state courts, but also maybe to do some things against executives who are perverting the original intent of the legislature.
Thanks, Sean. Well, thanks to all three of our speakers for joining us today. Obviously, there's going to be a lot of debate around these issues in the next year, so please follow their work closely, and please join us for future AEI events. But again, many thanks to Ned, Derek, and John for joining us today. And please join AEI for our next online webinar.